Good morning. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with Labor Attorney Jung Bong-soo, we will discuss about the Labor Standard Act Article 23, which is the restriction on dismissal. So, could you define this Article 23 first?
Hello, how are you today? This is Bong-soo Jung, Korean Labor Attorney. This article, the 23 of the Labor Standard Act, stipulates that employers shall not dismiss or reduce wage or demote or other punish the employee without justified reason. So this article is very important. So even though employee agreed the condition for the termination of employment, but if that is not justifiable termination, then it become a unfair dismissal. So for example, anybody can inform the other party for the termination employment contract. So only the other party can pay 1 month's additional pay. But such a mutual agreement in writing could not be acceptable because labor law requires justifiable reason for termination. So this article 23 is very important. Some exception is when employer agreed on mutual termination. Also employer cannot operate a business due to their decision to close their business, then it is accepted as a kind of termination. The other one is not possible. Also, even though there is justifiable reason, employee cannot fire people during the occupational the accident treatment period. So also 30 days after they are recovering from such an accident. Also the other one is the maternity leave period. So employee cannot fire the female employee who is under maternity leave. Yeah.
I see. Thank you very much for your detailed explanation. So, under the article, you explain about the overall definition and some exceptional cases. So, in case the worker in a company, from the employer's point of view, if the worker does not meet the general rules and regulation of the company, what will be the justifiable reason for the employer to dismiss the worker?
Yeah, I think the dismissal is very difficult in Korea. So employer, instead of firing or dismissing people, they suggest some cordial or some mutual termination agreement. So in this condition, employer pays certain the early retirement package, then employee accept it and sign the termination letter. So this is a mutual termination agreement. So it is possible. Also many companies adopted this system so that they could avoid any legal litigation or some application for unfair dismissal. So in the employee's perspective about this issue, so employer can fire people when they have justified reason for this termination. Also in this justified reason, there are 30 different types of dismissal. One is employee violate company's regulation, then it is disciplinary dismissal. Or the other one is when employee has a personal issue the terminal illness or some the traffic accident which is not related to the work, then it is a personal accident. Then they cannot provide the labor service. Then employee can terminate their employment contract because of the reason attributable to the employee, because they could not provide the labor service. Also, third case is the managerial dismissal when company suffer from the long time deficit or very reduced sales, then they could not operate their business as usual, so they need to save cost. Then labor cost is biggest, so without saving cost, if they could not survive in the market, then it is accepted as a managerial dismissal. So in this case, it is accepted as a justifiable reason for termination. Yeah.
I see. So based on this article, as a labor attorney of Gangnam Labor Law Firm, do you have some memorable case that is, the employer or worker was dismissed by unjustifiable reason, and you had win the case?
Yeah. So I have published the dismissal manual. So the terminology of this textbook, it is a dismissal manual. So many people say something very interesting. I mean, it's kind of topic is very strange for this textbook. So in the case, I suggest that mutual the settlement in any worst case is the best policy for employer and employee. When they get to some agreement, then they can keep maybe good relationship. But if they receive some verdict from labor commission for the dismissal case, then even though employees has served that company for many years, but they become very unfriendly, or it's a kind of they become enemies. But for employee, they served for their company so many years, then it's part of their life. But if this case is solved by this kind of verdict by the labor commission, I think we could not accept we could not receive a very positive result. So my suggestion is, in any worst case, getting to some good settlement is the best policy. So it was severe violation, then company pay 1 month or 2 months pay for early notice for non-notice for dismissal. So it kind of dismissal allowance, but it is a kind of unfair dismissal. Maybe company instead of reinstating the employee, they can pay good package for voluntary resignation. Then company pay good package for them to accept. Also, employees' case, they could not come back, return to work, and could not work as usual because they cannot. Their company cannot accept their employment anymore because of they hate their behavior something. So best policy in this case is getting to good settlement between employer and employee. That is my experience that I want to suggest to both parties, employer and employee.
I see. Thank you very much for your detailed explanation and introducing the best policy.
Okay, thank you for watching. Bye bye.